Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip is a follow-up from last week's contract tip. Last week the tip, or whatever order you're watching these videos on, in whatever order, and I do encourage you to browse through the channel, and you can use the search feature too, the little magnifying glass, to find different topics. But the last video I did was on the GAR, Georgia Association of Realtors contracts, the 8-day unilateral extension that is provided for in that contract form. And at the end of that video tip, I went on to say that it's not a law here in Georgia. Those were just terms that the buyer and the seller agreed to per that contract. It's not in, for example, the RE forms contract tip, a HUD contract, new construction, builder's contract, so forth and so on. It's just a provision of that particular contract that a buyer and seller had agreed to. I did reference, however, that in the RE forms contract, there is some verbiage referencing the TRID laws, the Truth in Lending RESPA Integrated Disclosures, that's what TRID stands for, that are new federal regulations, new since October of 2015, from the Consumer Financial Protection Bureau. And basically part of those regulations indicate that it is prohibited, a closing is prohibited if a lender has not sent out the 3-day required disclosures required per those federal regulations. So if you do not have any unilateral right to extend, what do? Well, the buyer and the seller are going to have to agree to extend a closing by an amendment, or the buyer is going to need to be in constant communication with the lender to make sure that the lender does comply and sends out those 3-day disclosures early enough to not delay closing. However, there is some verbiage in the RE forms contract that does address this situation, not with a unilateral right to extend. So let me point out where that is to you. So the first thing I want to talk about is the closing date is agreed upon between the buyer and the seller in the actual contract. So that's RE Form 100, Contract for Purchase and Sale of Residential Real Estate. And in paragraph 4, the buyer and the seller agree upon a specific closing date. And again, if that closing date needs to change for any reason, it must be changed only by agreement between the buyer and the seller on an amendment. So where did the TRID laws come into in terms of lender needing to not being able to close a transaction if they have not sent out the 3-day disclosure? Well, in the standard terms, which is RE1, and please go back and review previous videos I've done on the RE forms contract. The standard terms are incorporated into the purchase and sale. Purchase and sales RE100. Standard terms are RE1. It is referenced in terms of there is a website that the buyer and the seller go to and look at and read and agree to all those terms when they sign an offer. I encourage each and every agent to pull these standard terms from the same place you get all the other contract forms, reference them as an exhibit, and attach them to your purchase and sale when you go binding on the RE forms, because that is where all the information is that the buyer and the seller, those are all the promises and the consequences and time frames and all the instructions. That's all contained in the standard terms. And I highly, highly encourage you as an agent to print those out, reference them as an exhibit, so both your client and the co-op client can read them and have them in front of their hand. Even though they agree that they've already gone online and read them, this way they actually can have them in their hand. So anyway, in the standard terms, under paragraph 6.3, where it describes the financing contingency, because the financing contingency is already agreed upon in the contract for purchase, and then in the standard terms where it describes what the buyer and the seller agree to regarding that, under paragraph 6.3.2, it does specifically state that if Fannie Mae, Freddie Mac, FHA, USDA, or VA Underwriting guidelines mandate compliance with any underwriting criteria expressly contrary to the provisions that the buyer and the seller have agreed to in the contract. Then those provisions shall prevail and be binding upon the parties, as long as these guidelines, however, if any of these guidelines result in an increase in cost or expense to the seller or affect the date of closing. So a TRID delay due to that 3-day disclosure rule would potentially affect the date of closing if the lender does not get that disclosure out in time prior to the closing that the buyer and the seller have contracted for. So a delay of closing, then the seller, at the seller's sole discretion, shall have the right to unilaterally terminate the contract within 3 days of the seller's receipt of notice of the applicability of such guidelines. In such event, the seller may terminate the contract by delivering written notice of termination to the buyer, which termination shall release both buyer and seller from any further obligations or responsibilities to the other. If the seller does not terminate the contract, the seller is deemed to consent to those changes that are mandated by the underwriting guidelines. So basically, where the GAR form has a provision under certain circumstances for a unilateral extension, in the RE forms, there is a provision under certain circumstances for a unilateral termination by a seller. So let's think about what that says. So it says the seller shall have the right to unilaterally terminate the contract within 3 days of seller's receipt of notice of the applicability of the guidelines. So what does that imply? Okay, you buyer's agents, that implies that the buyer must first send notice to the seller. So if you are working with a buyer and the buyer gets notice from the lender that they are not able to meet the contracted closing date due to the federal mandate per the TRID provision under the Consumer Financial Protection Bureau laws, that they have to send out those disclosures and cannot close for 3 days. First thing, the buyer, you buyer's agents, you need to send notice to the seller. Now notice, and I've done tons of videos on notice. Notice is not one agent emailing the other agent. That does not satisfy the terms of notice per the contract. So what do you need to do? In the RE forms, you need to go get form RE 260 called notification. Looks like this. And what you do is you fill out the following notice. So you fill out whatever it is. The lender cannot close per the TRID guidelines, blah, blah, blah. Cannot close on the contracted date, closing date to be, and you put in a date. And then the buyer must sign it. Notice must be signed and delivered per the terms of notice, but it must be signed by one of the parties in the transaction, either the buyer side or the seller side. So first thing you have to do is the buyer must fill out this notification form, send the notice to the seller, and then the seller, upon receiving the notice, has 3 days to either unilaterally terminate, or if the seller does not terminate, if the seller does not terminate, then the seller is deemed to agree to whatever was on the notice. So if the seller is going to terminate, the seller would then has 3 days, again, not agent-to-agent email communication, but the seller must then use the notice, the termination of agreement. And that's, don't recall the form number off the top of my head, but I'll put it in the video. But anyway, the seller then, within those 3 days after receiving the buyer's notice, must terminate. If the seller does not respond back to the notice, does not terminate the contract from the notice of a delay and new closing date from the buyer, then it is deemed that the contract deems that the seller agrees to that, and you have a new closing date. So again, a very different way of handling a potential delay based on TRID. Now, this is not any delay from the lender. Again, the terms of being able to use this is only, let me read it again, is only if the underwriting guidelines result in an increase in the costs or expenses to the seller or affect the date of closing. So take a look at that. Again, if you're binding under the RE forms, you need to make sure that you understand that and make sure that you comply with the terms of notice, which again is all spelled out in the standard terms. Thank you so much for watching. Hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.